please the court, the appellants will address 4 issues that are before this court. This case is going to be the seminal case that will set the rules for these questions throughout the state on the questions of electronic recounts and the ability to switch methods during recounts. The 4 questions are, were the electronic ballots ever recounted? Did Section 19253 require the BB paper ballots to be recounted in this case? Can a recount requester change counting methods during recount? And 4th, were the 71 provisionals ever recounted? The first question for this court is, were the electronic ballots ever recounted as a matter of law? This is a matter of first impression because no court has previously been asked to uphold a recount where only one component of the voting system used to conduct the purported recount of the electronic ballots was used. The appellants contend that the electronic ballots were never recounted for 2 reasons, and this will be a theme throughout the appellant's case. There are only 2 actions that legally are sufficient to constitute a recount of any ballots. There's many actions you can take with respect to a ballot that don't constitute recounting them. 15627A provides only 2 choices, a manual hand recount, and all parties agree that did not happen as to the electronic ballots. And the second option is a recount by means of the voting system used originally. The legislature, however, carefully defined what a recount requester would have to do in order to do a recount by means of the voting system used originally. It wasn't an endless loophole for novel approaches to recounts. They carefully defined what was meant by voting system in Elections Code Section 362, which specifically defines voting system as, quote, any system and its software or any combination of these used to cast or tabulate votes or both. The cast or tabulate language is crucial because that's what was ignored by the registrar in this case. And in order to make sure there's no misunderstanding of what's meant by the word software in 362, the legislature defined that term in Section 355. It said software is, quote, ballot cards or papers, printouts, and test programs. That's also crucial language that was ignored by the registrar. In this case, the VVPAT paper ballots are papers and printouts, and they were used to cast the ballots, as was the VVPAT confirmation program. Now, the registrar, at the respondent Janet Nguyen's request, only employed one of the components of the voting system used originally. That component being the MBB memory stick that was used to tabulate the vote. Keep in mind, the votes, the electronic votes, there were 3 components that were used. The VVPAT was used to cast, and then the paper manual tally sheets were used to tabulate the electronic write-ins, and then the MBB memory stick was used to tabulate the electronic votes. Those were 3. But then on recount, they dropped down to 1, and they simply used one of the 3 components for the recount, and that's not what 355 and 362 permits. They just merely re-downloaded the MBB memory stick, and this violated 355 and 362. And all of this analysis is conceded. We provided 10 pages of analysis to this court, going through all these definitions and laying them out, and there's literally complete silence in the briefing.
Why didn't you ask the trial court to order a recount?
Because that's not an option that's available. That would be the 15632 is very clear, and there's a time frame beyond which you can no longer request a recount. That time period will all come and gone. And 15632 provides.
Didn't ask within that time frame either.
It is certainly true that the appellant could have requested his own recount. And in fact, if what the trial court did is upheld, that's what's going to happen in the future every single time. But in this case, once the recount was requested, the sole remedy available in an election contest under 15632 is that the trial court determines that all the votes were not counted. It says that the recount shall be declared null and void. That was the only remedy we had during the election contest. And one of our central points in our briefing, Justice Sills, is that we believe that if the trial court is upheld, that every close election in the future will do exactly what you suggested. Both sides will request a recount, the winner and the loser. And they both will tactically count the ballots, so that the ballots, that the winner, the benefit of the winner, he'll have counted by machine, so that they won't be disqualified. he'll have his opponent's ballots counted by hand, looking for squiggles and flowers and that sort of thing. So those will be counted, and he will, or she will then win again. The person who narrowly lost will do the flip side of that recount, and they will both win. So we will have 2 recounts if you request it in a timely fashion. But once that time frame is gone, you can no longer request the recount, and then the sole remedy under 15.632, if in fact the recount was never completed, is to void it. If all of the ballots weren't counted, if for tactical reasons or whatever reasons, the recount requester said, I want to stop, I don't want you to do this, and they in fact don't do that, and those ballots were not legally recounted, then I think that ends the recount under 15.632.